This morning on the Ag Issues program. A pleasure, as always, to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
All right, let's get to it. And if, like I said, if people heard this morning's agricultural law and tax report, this was a topic that you discussed, preserving the family legacy. And it's one that many, of course, obviously many families work on for many years, many generations as well. But, some of the items, facing the economic reality of, say, long-term care, as you put it, on the agricultural law and tax report, that could wipe that out very quickly.
Yeah, it can. And this is one thing, Greg, where we can do a lot of planning, financial planning and tax planning and entity structuring for farm families. And if you miss this and this gets triggered somehow by some physical ailment or some event that causes a need for long-term care, then the whole plan could get blown up. The cost of long-term care is about, nationally, it's pegged at about $11,300 per month. So over $135,000 annually, with the projections of that amount doubling over the next 20 years. And some projections I've seen have it more than doubling over the next 20 years. And so you could be looking at $250,000 a year if we're working on an estate plan or a succession plan for somebody that's in their 60s or early 70s. And by the time they're in their late 80s and 90s and need long-term care, you're looking at $250,000 or $300,000 per year. So what's the plan in place to protect assets so that you can preserve them to pass them down to the next generation without losing the assets to pay for a long-term care bill? And it's a huge issue. It's a massive issue for people to think about.
Well, and it's one, too, that there are common mistakes that farmers make as well. And
Mhm.
that's really waiting until the health crisis occurs if they want to do some, like, for instance, transferring the farm to their children as well. In other words, it's the called, I believe, the 5-year look back rule.
Yeah, and what you're talking about there is part of the Medicaid program. Now, Medicaid is a cooperative federal state program, so the rules differ from state to state, the way the states implement the federal rules. But this is not Medicare, and so that's one of the first areas where we have confusion. Medicare generally only covers short-term rehabilitative care, and then it only covers 100% for the first 20 days. And so what most families end up looking at perhaps is Medicaid. And you're right. I think the most common mistake farmers make is waiting until a health crisis occurs to transfer the farm to their children. Well, you can't do that and qualify for Medicaid. It's a means tested system, and there is a 5-year or 60-month look back period. It's going to catch any uncompensated transfers made within that 5-year window. So if you transferred assets such as, let's say, a quarter section of land or a fleet of equipment for less than fair market value during that window, you're going to trigger a penalty period, and that's the duration of time during which you're technically eligible for Medicaid, but the state's not going to pay until you have paid personally enough to match the amount of the transfers that you made within that 5-year window. And so you've got to bridge that gap at private pay rates. And keep in mind that this is a totally separate system from the federal gift tax system. That present interest annual exclusion gift, a lot of people know, well, that's $19,000 per recipient per year. I can give that away. I don't have any gift tax issues. Well, that's totally distinct from the Medicaid rules. You can gift $19,000 or property worth that much to an individual during a calendar year. You don't have to file a gift tax return. But if you gift any non-exempt asset of any amount, that triggers a Medicaid penalty if you're inside that 5-year look-back period. So we got to keep in mind those are two distinct things.
Can you tell us more about, if you want to remain in control of their operation while ensuring that it remains invisible to Medicaid? Tell us more about the Medicaid Asset Protection Trust program.
Yeah, well, that's kind of the gold standard here on really aggressive planning to protect assets. It's an irrevocable trust. So once I transfer assets to this trust, then I don't own them for Medicaid purposes. And that's the key point. I don't own any assets. Those assets are in a trust. And then the trust can be structured with specific protections in it. So I can retain the right to, for example, live in my farmhouse for the rest of my life. I can have the right to the income from the trust, so I can continue receiving rent from the land or dividends from investments held by the trust, but I don't own the corpus, the body, the assets of the trust. And if it's drafted correctly as what we call a grantor trust, then the property will still get included in my estate at death. My heirs will get a basis step up in those trust assets equal to their fair market value at the time of my death. And that can, if they were to sell those assets, that could potentially save hundreds of thousands in capital gains taxes upon eventual sale. But there's a difference here, Greg, between the Medicaid rules and the IRS rules. And that's a key point that we need to focus on.
Yeah, and let's talk about that because I'm sure there are significant differences and things that may not exactly match up as far as those types of rules, those two types of rules being the Medicaid rules and against the IRS rules.
Yeah, and I often get questions, well, how can I retain income from my assets and my right to live in the farm home, but those assets not be treated as available for Medicaid eligibility purposes? Well, we're talking about two different things here. Medicaid and the IRS use two entirely different set of rules to define ownership. Medicaid eligibility is governed by a different section of the United States Code, excuse me, and state-specific regulations. So if I have an asset in an irrevocable trust to be non-countable, then there has to be no circumstances under which I can access the principal.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest this morning. And Roger, before we went to the break, I don't know if you were finished on your point concerning the Medicaid rules versus the IRS rules in talking about the preserving the family legacy and some of the things that farmers are able to do or need to take a look at.
Yeah, well, let me back up on that, and sorry for the problem there. I got a tickle in my throat and hadn't brought any water to my office this morning. But my point here is if you draft the trust correctly, or if it's drafted correctly for you, then the heirs still get the basis step up, and you don't have to have those assets in the trust be deemed available to you for Medicaid eligibility purposes. It's kind of the best of both worlds. It's a non-countable resource, but yet you still get the income from it. But the trust has to bar the trustee from distributing trust principal to you. So the distinction between principal and income. So you can retain the right to the income, the right to live in the home, but that land and the structures are locked away in the trust. And so the IRS doesn't care about the Medicaid no access rule. Medicaid doesn't care about the IRS rules. And that's really kind of the needle that's trying to be threaded here with this type of a trust.
And really, too, not only is effective planning not just about hiding assets or being able to protect assets, but it's also about the business continuity as well.
That's right. That's what we're trying to do overall, is protect the transition of the farm from one generation to the next. And this is just a component of that transition plan to make sure the assets are protected in the event of long-term care. Now, there are other things that you can put with this. You can have long-term care insurance, those types of things. But the trust strategy is really kind of the gold standard that we look at, particularly when there is the desire to transition the business to the next generation and you have high-dollar assets that are involved.
But the other part, and this probably can't be emphasized enough, the wait-and-see approach probably ends up costing you the most in your estate planning.
Yeah, for most people, you don't want to do that at all. If you end up, say, entering a nursing home tomorrow or needing in-home health care, which can also be very expensive, then your options are basically limited to spending your finances down until the family's nearly broke. And so a lot of times what we want to do is start that 5-year clock running, make your asset transfers through some type of structured gifting program or through a Medicaid asset protection trust, And that gets the clock going. Then you've got 5 years, and after 5 years, you're in the clear, and the transfers that were made will not be caught for Medicaid eligibility purposes. So securing your legacy means acting while the pen is still in your hand and the clock's on your side. And none of us know how much sand is in the top of our hourglass, and we always have to keep that in mind.
Roger, let's switch topics. The first quarter of what we have seen this year has been really a watershed moment for agriculture and food law, but that does signal a shift as far as several items are concerned. Mandatory digital tracking of individual livestock to specific moral and scientific phrasing required on a retail label, that is. The legal infrastructure governing our food system is undergoing a massive architectural overhaul. But you wrote an article looking at the major developments that are redefining the boundaries of the American food market.
Yeah, we've got several things going on at the same time, Greg. We've got the RCAF versus USDA case that's up in South Dakota, and the court is currently weighing a motion for summary judgment on that one. Now, last September, you and I talked about this a few months ago. The court issued an order denying USDA's motion to dismiss that case. Of course, what is at the heart of this case is USDA's mandate requiring electronic ID ear tags for cattle and bison that move across state lines. And the argument is that that's an unauthorized mandate and it's just arbitrary and capricious. So by mandating a high-cost technology without requiring corresponding electronic readers. And so that's an issue that's out there. If the court does find in that one that USDA failed to provide reasoned decision-making or ignored what the law calls less burdensome alternatives, the rule could be vacated. And so I think that's kind of a bellwether case for how much deference agencies are going to receive now in this post what we call Loper Bright area, where the Supreme Court changed the rules 2 years ago, and where the courts now are more skeptical of broad agency interpretations. So that's one. And then down in Texas, we've got going on what I call the battle of the labels. Texas passed a law known as the Make Texas Healthy Again Act. And in last month in February, the District Court for Western District of Texas signaled that the law was likely unconstitutional when it issued a preliminary injunction. And what that law does is require warning labels on products containing certain ingredients. This is basically a law going after the fake meat type people and commodity that put that out there. And the court basically said, now we got some constitutional First Amendment speech problems with that. As long as the label is accurate, they can market these products. So that's one to keep in mind. And then you've got over in Massachusetts trying to do the same thing that California did a few years ago with Proposition 12 in California. They had Question 3 in Massachusetts, and that case has gotten to the First Circuit Court of Appeals, the U.S. First Circuit Court of Appeals, and they upheld the law saying, this is the law that prohibits the sale of pork or eggs or veal in Massachusetts unless the animals were raised with the space requirements that Massachusetts law requires. And just like the court did out in California and the Supreme Court upheld it, the court here said that that law is constitutional. And of course, the problem on this is that I think it so-called balkanizes the national economy. You've got one state dictating agricultural practices in another state. You got Massachusetts telling Iowa hog farmers how they're supposed to raise their hogs. So yeah, we got a bunch of food law stuff that's going on right now, Greg, all across the country.
And reportedly, Oklahoma may be coming up on that docket sometime soon with the Proposition 12 type law.
Yep, they could on that same issue, and so I think we'll see it in other states too. This is really an issue that the Congress needs to deal with in, say, a farm bill, and it was something that Representative Steve King, back in 2016, had in the House passed farm bill, and the Senate killed it. And here we are today with all these cases in the states trying to do these things. And I just go back to where we were 10 years ago. Had they kept that in there, we wouldn't have this problem.
But as far as the next state is concerned, Florida may be the next up concerning maybe a case going to the Supreme Court.
Yeah, there's Florida's kind of done some of the same things that some of these other states have done, and they've gone a little bit further. And so we'll see on the label issue what's going to happen down in Florida. So yeah, lots of activity, lots of states all over the country, and it's really kind of an interesting start to 2026 on these issues.
And it's the proverbial stay tuned, because I'm sure there's going to be plenty more coming down the pike.
I'm sure you're right. It's never a dull moment for me.
Yeah, exactly. All right. Roger, we need to let you go. Obviously, if people want more information, they can search you out on social media.
That's right. Both of these articles that we talked about today are posted to my blog and cross-posted over to Ag Manager at K-State. And then I have a new article posted on my Substack yesterday involving some insurance issues for farmers and ranchers.
All right, sounds good. Roger, as always, appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.